Is India's criminal law reforms a game changer? Is what the central topic of our discussion today. India's government announced three new bills in Parliament last week, promising a significant transformation of the criminal justice system prevailing in India. A trio of criminal laws are intended to be abolished and replaced by the bills, unlike the Code of Criminal Procedure, the Indian Penal Code, and Indian Evidence Act are old colonial laws. For further discussion, the bills have been referred to a parliamentary committee, and it appears that they are driven by the goal of delivering justice rather than merely punishing. The criminal justice system in India is seriously in need of reforms. Police investigations often result in tragic miscarriage of justice. Jails are overfilled with under trials, and courts are clogged with 50 million cases. Almost no one would dispute that laws need to be updated from time to time in order to remain relevant to changes in technology and society. However, a preliminary scan of the new bills indicates that they retain more than 80% of the 160-year-old Indian Penal Code. As recently as 2018, the 50-year-old Code of Criminal Procedure was updated and amended. The language remains largely unchanged from the original. There is some doubt as to whether if deletions and amendments would have achieved the same result. Despite the new names, the majority of these bills retain the same existing provisions. India could have amended the existing laws instead of repealing them and dealing with the massive administrative challenges that would follow. In countries like Singapore, Malaysia, Sri Lanka, and Bhutan, the colonial penal code is still in use. Singapore recently updated it with modern requirements. The law on sexual violence in India was also changed and updated in 2013. That would have been the best way forward, not what the bills propose, as they seem to be at this point of time. Nevertheless, it does not mean that the whole new codes will be introduced and given obscure names when, in essence, the old laws still will remain. When 80% of the original language is retained, criticism is that it is unnecessary to refer to the Bharatiya Nyaya Samhita (BNS), which replaces the Indian Penal Code, and the Bharatiya Nagarik Suraksha Samhita (BNSS), which replaces the Code of Criminal Procedure, and the Bharatiya Sakshya Bill, which replaces the Indian Evidence Act, in their Sanskritized Hindi names. Indian laws have official translation in the official languages of each state. So, it is unnecessary to refer to the IPC, CRPC, and Evidence Act only by their Sanskritized Hindi names. As opposed to 1898 version, the 1973 version of the Criminal Procedure Law is called the CRPC 1973. Sanskritized Hindi names are apparently intended to symbolize the de-anglicization of criminal law, essentially removing sedition and its apparent equivalent, Section 150, are welcome, since they do not use overly broad terms like disaffection or hatred, as well as criminalizing secessionism, separatism, and armed rebellion. It also targets subversive activities and endangering the sovereignty, unity, and integrity of India. But the terms should not be misused. In the new Section 194, equivalent to Section 153B IPC, making or publishing false or misleading information that threatens the sovereignty, unity, integrity, or security of India is punishable. Despite the addition of sections for mob lynchings and organized crime, hate speech remains omitted, despite years of debate about how to define and punish it. In absentia, trials of proclaimed offenders are permitted under the Procedure Code. It is welcome that seizures should be videotaped. Similarly, authorities failing to grant a sanction within 120 days will be deemed to have granted it. Police custody to be permitted beyond the current 15-day limit under the remand provisions, which has caused some controversy. It is necessary to critically examine the new laws, but not to give them the new names. No matter where the crime occurred, anyone can file a police complaint at any police station. Electronic evidence and forensics should be used more often during investigations, as well as video recording of search and seizure operations. New forms of punishment are introduced, such as community service. Though video trials and holding trials in absentia, they advocate speedier justice. Despite this, some of these laws still raise skepticism. As a result, the new offences acts endangering sovereignty, organized crime, mob lynching, terrorism, rape by false promise to marry continue to be so vague that it gives the police unreasonably broad powers of arrest. It is constitutionally unacceptable to exercise police powers in such a vague manner. Indian governments have used the draconian sedition law from the colonial era against students, journalists, intellectuals, social activists, and critics of authority for decades. Despite the controversy surrounding the law, the government claims it has made a historic decision in repealing it. However, this is not entirely true. As a part of the new bill, the sedition law has been replaced with another that punishes acts that endanger the sovereignty, unity, and integrity of the country. Therefore, this defines sedition in a broader sense. According to the new bill, sedition should have been eliminated. However, it has been retained and perhaps further strengthened as well. Certain crucial aspects of the bills are overlooked. Despite India's tough laws deterring violence against women, marital rape has not been criminalized. The Supreme Court is also preparing to hear petitions seeking criminalization of marital rapes. Offenses criminalizing speech must be re examined. Then there are semantics. It is necessary to remove the terminology used in the code for the offense of outraging the modesty of a woman. There should also have been a revision of the laws regarding religion and blasphemy, some of which remain too vague and ambiguous even to qualify as criminal provisions. There are some proposals that seems fuzzy. It is unclear what punishment would be the most appropriate in a case, but certainly not the death penalty. Providing a minimum sentence of 7 years in prison, life imprisonment, or even the death penalty for every individual within a mob, a group of 5 or more people, is quite uncommon. For mercy authorities to reduce the death penalty from death to life and life to 7 years at their discretion is uncommon. Just imagine a mob of 50 people being sentenced to death for murder. Furthermore, the investigation, the evidence, and the manner in which the trial is conducted are more problematic in the cases as per the new Sanhitas. The offences shouldn't be grouped with murder when we know there are social and political factors that may influence the cases. For determining the guilt, collecting evidence, and investigating, a different approach may altogether be required. The Indian Penal Code, which is 163-year-old, contains embarrassingly outdated provisions. The punishment for a thug is a fine, and the offence of obscenity is derived from Victorian morality. The new bill retains other outdated parts and definitions. except for the reference to thugs and punishment for them. In any case, changing an existing law based on the fact that it was enacted during the colonial period does not provide enough justification, especially if the name is changed from English to Sanskritized Hindi or to any other Indian language for that matter. Most importantly, the bills also propose forensic investigation at every crime scene, posing formidable institutional challenges. However, the forensic system in India is not yet prepared for that. Everyone knows that. There is some consolation, of course, to be found in the fact that the Sanhitas will be scrutinized by a parliamentary standing committee, and it's the hope of all in India that the Parliamentary Standing Committee will look into the aspects most keenly and point by point, since the consultation process while introducing the bills appears to be inadequate. Hope the information is useful. Thank you very much.